All right, so let's start today event. I think this is the first time, and actually I never found any presentation for L5M3. So it must be the first time I do on this topic. I do on this module about a module in level 5. Although before we did a few events on L5M1 and L5M4, but this is the first time we do L5M3. And this is a module about managing the contractual risk. In other words, it's kind of like the elaborated or more difficult version of FRM3. So we shall see, if you read the study guide, you can see that there are pretty many things about contract and legal problems here. So that could be quite challenging at first for anyone without any background in legal or for anyone who has never or who may forget the F3 before. Anyway, then today, then I due to the lack of time, I can only focus on a few key topics that I think that they will be more important in F3. And we shall look at the following ones, the following topics. First, let's come back to a pretty regular and also familiar topic that is about the key term in contract. In FM3, if you read the study guide and also you look at the syllabus, then the first thing you see in the first chapter is about the formation of contract. We visit again the five elements or five factors that five elements of contract formation: offer, acceptance, consideration, uh, capacity, and intention. But I think that part is very well explained. And also, if you study from 3 already, then that will be quite easy for you. But here, then I think we need to visit other part that is the key terms where you may see of a new term that is the guarantee. And second, let's visit some new topic in Alpha 3 about the types of different types of bridge. Okay, major bridge, minor bridge, anticipatory bridge, and fundamental bridge. And then we have the conflict resolution and the legal consequences of bridge. So for this module, then it is about contractual risk, mostly about what happened if a supplier failed to deliver a contract. So therefore, we focus mostly on the bridge and how to solve the bridge with the legal sense and with legal tools or in legal way. All right, so let's start one topic at a time. First, with the key terms in the contract for FM3. Then here I would like to highlight three terms because very likely that you may see them in the question, especially in probably in the matching question. That is a new type question in level 5. Here I would love to highlight indemnity, guarantee, and liquidated damages. With indemnity, then it is essentially a promise by a party to another party, and they promise that they will compensate the other party in certain cases or in certain event. So it is often used when it comes to a third party claim, especially when the other party has some risk that they may face the lawsuit or claims or sue for damages from a third party. Therefore, indemnity is like quite common in procurement and in other sectors as well. And it is the it is the foundation for insurance. Since the insurance company may need to compensate the insured in certain cases, in certain event. And indemnity is actually the foundation for that principle. So we can make a supplier to indemnify us or to compensate us in case that they don't really deliver the thing that they promise, or they fail to or they fail to comply with some requirements and cause the damages to a third party. Okay, that is indemnity. Second, we have a new term here, that is guarantee. So guarantee is another type of promise, but we have three parties here. There will be a third party or the guarantor promises to fulfill the performance or to fulfill the obligations to a beneficiary. So basically, this is the contract between this is a contract between a party or a principal to a beneficiary. But the principal has no reputation, or it is just a small company, and the beneficiary has very genuine concern that the principal party may not perform the contract. So they want to have something firmer, something more robust for them, especially when it comes to the contract risk. Therefore, they may require the principal party here to have some promise or some guarantee from a trusted third party. The trusted third party could be a parent company that is well known and huge and has a lot of financial resources, or a bank where they may compensate when something bad happens. So the third party promised to fulfill the contract and to compensate the other party in case that the principal party failed to perform. Failed to perform. And this kind of term is very popular and frequently used in certain type of contract where high risk performance may happen, like in construction or in exploration of oil or in mining. You know that in mining or in oil exploration, then the contract risk is very high. They need to invest in a new vehicle, and then that vehicle may need to go like into the middle of the ocean, where they may face several risks like piracy or storm or hurricane, and the ship may sink or the oil rig may sink. And similarly, when some mining company operate in a new country, they may see some unstable problem, and they may need to create a new company there. So the problem is the new company may not have enough reputation to work with certain partner like bank or other major supplier. So the supplier may want that buyer uh, to be guaranteed by the parent company. That's why we have the guarantee here. We can ask the supplier to have some guarantee from a trusted third party, or the buyer may need to have the guarantee from a third party. This works like something that is more robust for the other party to work with, and they may feel like safer to have such guarantee. And finally, we have the liquidated damages. Actually, I think you are very familiar with this. This is just a term about predetermined amount of money that need to be paid if a party breaches the contract in certain terms, especially in some obligation that they may feel harder. They feel harder to estimate the damages. So this kind of term may provide some certainty to the bridge, and also facilitate the dispute resolution process when, especially when the damages are very hard to calculate exactly according to the law. Therefore, liquidated damages is pretty popular in supply contract, in contract within procurement job. But to be enforceable, the liquidated damages requires some conditions, like it needs to be a genuine estimate of loss, and it needs to be expressed in the contract. However, as you know, liquidated damages clause is often compared with penalty clause, and although they share some similar characteristics, like they require some payment, but according to older doctrine from 1915, then liquidated damages is why liquidated damages is enforceable and penalty is not. But according to a new doctrine from 2015 onward, then we know that both liquidated damages clause and penalty are enforceable. Wait, I need to show you that. Okay, hold on. Yeah, we both know that in study guide and also in the exam, then they often highlight that penalty clause is unenforceable, while liquidated damages clause is enforceable. But to be enforceable, then liquidated damages clause should must be qualified under a few tests, like they must be a genuine estimate loss, and they must be expressed in the contract. So all of that requirements, all of the requirements come from a source that is the case law, the case of Dunlop v. New Garage in 1915. It's about 110 years ago. Okay, a lot of time. So here, in this case law, then they set out some principles and some requirements for liquidated damages clause. Okay, like it must be genuine estimate loss and expressed in the contract, and it is enforceable. Why penalty is unenforceable? But this one is reversed in 2015, okay, much recently, but also a decade ago. In the case of Cavendish v. Talan or Cavendish v. Magdesi. So in this case, then we see that both liquidated damages and penalty are secondary obligation. It means that they only arise, the obligation to pay under these clauses only arise when a party breaches the contract. Okay, it could be a minor or major breach. Anyway, then it must be a breach, and then a party incurs such obligation. And while liquidated damages clause is a genuine estimate of loss, but penalty is more kind of like a deterrent method. It means that a party may want to threaten or may want to warn the other party that if they do certain part, for example, disclose the information to another party, to a third party, then they may face very huge penalty, like a very huge sum of money that they need to pay. So that kind of warning is deterrent, right? And penalty is deterrent. They prevent. It is an attempt to prevent the other party to breach the contract. So with such very honest and rightful purpose, okay, and also legitimate concern, then penalty should be enforceable as much as liquidated damages clause. So if you apply penalty clause in the contract, then it's fine. And according to British contract law, then it's fine. Okay, at least when I update, uh, after 2015. But unfortunately, if you have concern about the exam, then they still apply this old doctrine, and this is not the first case. Sorry, this is not the only case that they apply this. Apply the old doctrine. Okay, later on we will see that they also apply another outdated doctrine in the exam. Anyway, then we all want to pass the exam. Therefore, let's look at this old and try to remember some principles like liquidated damage clause must be expressed and it must be genuine estimate of loss. Okay, that's all. There's nothing to see more. All right, so I also remember that in the exam, then you may see a few questions about penalty, like it is unenforceable. Okay, it is unenforceable. So we may still select unenforceable as a characteristic of penalty. And in the exam, you may see very familiar part about insurance. It means that we may revisit some type insurance like employee insurance, product insurance, or professional indemnity insurance, especially the last one, the last type insurance here. Basically, then you may need to recall some insurance types from F13. So all of these things are liability insurance. It means that it protects you from paying the damages. Or actually, then it helps you to compensate a third party when something bad arises. Like employee insurance protect an employer or protect a company or an organization when their employee engage at work and has some injury or even death. So this kind of insurance may have the employer to compensate that unlucky employee. Similarly, we have professional indemnity insurance, well, the same way. Uh, a consultant firm or a law firm or an accounting firm may give the advice to a client, and that advice is pretty bad and cause some damages to the client. So this kind of insurance may protect that service firm when they give the advice, especially the bad advice. It has like when something happened and if the client rely on the advice and they have like incur some loss, then insurance may pay for that damages. Okay, so we can rely on this kind of policy to limit the loss that a firm may face. Okay, so that's enough for the first part, some key contract term. Now, let's continue on second part about different types of bridge and their consequences. But before I talk about different type bridge, then we need to look at the classification of contract terms because each bridge is kind of like attached to different type term. So we need to look at this first and then consider about the type bridge later. So the terms here could be classified into three groups. First is condition, second, guarantee, and third, innomin. Actually, sometimes I think the English language is kind of like they run out of vocabulary, so they use some word that we normally use for other purpose. For example, condition is the word for something like a certain situation that we are facing. Or warranty, sometimes it can be used for a promise from a producer. Like if this product breaks before within 1 year, then we may replace that for you, etc. So I think that they have very poor imagination where they use the same word here for for complex legal matter. Anyway, then it is well established, and they already use these words in the contract law and in the case law. So we must learn that, although it could be confusing at first. So first, with condition, then they are the major terms of the contract, and the breach of these terms means the contract is defeated in purpose. Okay, so the purpose of the contract cannot be reached anymore. Therefore, the innocent party, in this case, in the breach of condition, could claim for both termination of contract and the damages. In a sale contract, then there are a few condition terms, like from the buyer side, then the condition could be in the fit for purpose term, or the quantity, or the right to sell, or those kind of thing. So condition for under the sale contract, then condition could have, we could see that they are very basic terms in the sale contract. So if the supplier breaches or violates these terms, then the buyer could terminate contract immediately and claim for damages. So that is to prevent the loss. But there are other terms like guarantee. Guarantee is capitalized minor, and if some minor term is breached, then we could not ask for contract termination, but only ask for damages if there is any. Sometimes the damages is so small that we may skip that. For example, I may ask my painter to paint my wall in blue, but they may use a wrong type of paint, and that may cause lighter a lighter shade of blue than I want. Actually, it is still a breach, and I feel like quite upset because I don't like that blue. I like another type blue. But anyway, then it is quite minor, and it doesn't cost me any real damages other than some of my upsetting emotion. So for guarantee, I could not deny to pay I could not deny to pay the painter because of that violation, because of that breach, because it's so minor, it's so small that I can waive my payment obligation. So with guarantee, then the breach of these terms does not lead to contract termination or something serious, but very small or very nominal damages. And unfortunately, conditional guarantee does not, they don't cover every cases. And therefore we have the final term that is innominate. Innominate means a term itself is not either condition or guarantee, and the consequence of the breach depends on the impact. For example, then I may require my supplier to deliver the satisfactory services, like pick up the phone within 3 rings. But the breach of that obligation depends on the consequence, and it could be condition in a case, or it could be major breach in a case and minor breach in another case. That's why, because of innominate and undecided nature of these terms, then we need to have clear terms and conditions. We need to have clear KPI, SOA that may enable you to decide when that bridge is major and when that bridge is minor. Like the bridge is major if the delivery of service is totally unsatisfactory, but it could be minor if the delivery is somewhat unsatisfactory based on our judgment or based on clearly defined KPI and SOA. So each type of term or the bridge of each type term could lead to different type of different type bridge and different types of consequences. In the study guide, you can see that there are four types of bridges. First, the major bridge, or in other words, it could be called repudiatory bridge. You may see this word for the first time. It comes from repudiate, or the noun is repudiation. So repudiate means reject, right? So this type bridge or this type bridge is known as repudiatory bridge. It means that the bridge is so serious that it means like a rejection to perform the contract. That's why it's called repudiatory bridge. You may see this word repeatedly in the study guide, but sometimes it could be confusing. So major bridge is also known as repudiatory bridge because when a supplier or when a contract party commit this bridge, then it's look like a rejection to perform the contract. So the serious bridge that allow the innocent party to terminate contract when they acknowledge that and claim for damages. So this bridge is kept like a defeat of the contract purpose, like the buyer never received the service or the goods they want. That is a major bridge. We also have the minor bridge, where it has no other name other than minor bridge. They are smaller breach or violation to the contract, and they may cause some loss on only nominal loss, or at least they may cause some inconvenience. So in this case, then the innocent party can claim damages, but they could not terminate the contract. If they try to terminate the contract, then that is a repudiatory breach, and they need to pay the damage instead. So minor breach only lead to minor consequences, right? We also have other type of breaches, including the anticipatory breach. So if major breach and minor breach could be real breach and they already happens, then anticipatory breach is something that not happened yet. And it only anticipated. It means that a party or the innocent party may know that it's about to come. So for example, this is very typical. The supplier tells you that they would not be able to deliver the goods at the date in the contract, on the date in the contract. And in this case, then you may decide to either accept that you may get your goods late, or you may contact a new supplier and replace the goods and terminate the contract with the current supplier. So with anticipatory breach, when a party or when the buyer has the reasonable, or they can foresee that the performance contract is not guaranteed, then they can terminate the contract and switch to another partner. And finally, we have fundamental breach. It's kind of like a thing in the past. Fundamental breach has very similar definition to the major breach, but it differ in some ways. First, it is something in the past, and we don't apply this anymore. And second, even if it is still applicable, then its doctrine is very different from the major breach. So the purpose of fundamental breach is that a party, you know that in the contract, then we could have some exclusion or exemption or limitation of damages, and that could lead to like, yeah, that could lead to some inconvenience of the innocent party, especially when the damages is so vast and so devastated that the innocent party may bear a larger risk of suffering financial loss. For example, a fire could destroy the whole factory, right? But the supplier, or like the supplier of fire extinguishing system or fire safety system, they may include some certain limitation in the contract, that their liability only limit to certain number, like only $1 million, but the total damages could reach like $10 million. So there are $9 million that the innocent party has not is not covered. So they may feel very insecure about such situation, and they may want something or some doctrine that help them to remove that limit or expand the limit to maximum damages. So according to Slay Guy, then fundamental breach also the severe or serious breach that go to the roots of the contract and deprive the innocent party from the whole benefit. They receive nothing from the contract. But the major use is that it is about to remove any limit or any exclusion of liability when something bad happened. Unfortunately, the study guide never mentioned that this doctrine or this type breach is totally outdated. Not recently, but since 1980, right? So we have two cases of fundamental breach that become audited in 1967 and 1980. Almost it's kept like 45 years ago, and the study guide never did update this. Although, yeah, it could be quite confusing for students. So currently we don't apply this doctrine anymore. Instead, the court in UK apply very basic way to interpret the contract. If the contract express what the parties want at the time of formation, then it should apply, and the court should refrain from applying some random or arbitrary rules to the contract. And second, the legislation also produce another product like the Unfair Contract Terms Act of 1977. So this act is already it provides a weaker party some tool to remove the limit or remove the exclusion of liability that is unfair for them. Therefore, now we have Unfair Contract Terms Act, right? And therefore, we don't need to have fundamental breach doctrine anymore. Unfortunately, then you still need to know this, because in the exam, they still apply very old rule like this. And you may see some keyword in the exam like fundamental breach could be it could go to the root of the contract or upend the contract severely. Okay, so there are keywords that help you to distinguish fundamental bridge from major bridge. But it is outdated, and now we don't have this anymore. So I just introduce this here. And with the bridges and damages, there is another small note here. Actually, then the innocent party may waive the claim. It means that they may abandon their right to pursue the claim. It means that once there is a breach, or once the innocent party knows that there is a breach, then they have two options, right? One is that they may terminate the contract, or they may sue the other party at court and claim for damages. Or two, they may ignore or waive the claim here. Waiving means the innocent party may accept that, yeah, there is such breach, but I don't care. You can continue. So they may lose the right to claim for damages once they do that. The waiver could be expressed and implied, just like the contract terms. So express is like they say that expressly. They clearly state that they will not enforce their rights. And imply means that although they acknowledge, although they know about the breach, but they decide not to pursue it. They decide to abandon and ignore the failure. So it could be a sign that the innocent party accept the breach, and therefore they move on. So they lose the right to pursue or to sue the other party for damages or for termination. All right, that's all for the bridges. Now let's move on the dispute resolution. Okay, so dispute resolution, I think it is the major part of this study guide. Since you see that it appeared in two parts of the study guide. Yeah, I don't remember well, but in the middle of study guide and at the end study guide, they introduce very lengthy text on different ways of dispute resolution. Therefore, we need to learn about 6 types of dispute resolution here. Like we have 6 ways of solving a dispute from negotiation, mediation, conciliation, adjudication, arbitration, and finally litigation. Each way have different advantages and disadvantages. First of all, negotiation is very direct, where where the parties try to solve the dispute directly by communicate with each other. And this way could be quick, and if the party know how to solve, then that could produce a very quick result. But there's nothing that impossible here. A party may not be cooperative in negotiation, and they may skip the whole process together. So although it is quick and secretive or confidential, but they are not applicable every time, especially when we have a party that don't want to solve the problem, don't want to solve the dispute through this one. Second, we have the mediation, where there is a third party try to facilitate the communication. And with the help of mediator, then the then the parties to dispute may find a solution. But also, there's nothing that both parties may join, and the mediation could be quite confusing as well, because although the mediator could be well trusted or well known to both parties, but there's nothing to ensure that both parties may join to this kind of process. Similar to mediation, then we have conciliation. Basically, it is just very similar to mediation, but with more active role from the third party. Here we call it conciliator. And then you may consider adjudication. So this is a process. This is a process that is very typical for, for example, we have in construction, where we have a third party who is an expert in that field, and they may hear the claim from both parties, and then have an award or a decision on dispute. So adjudication is legally enforceable. It is legally enforceable.
Unknown caller.
But it is only available in certain type of dispute, like in construction or in some area that they are allowed to use it. So not applicable every time. And second, both parties need to agree to go to adjudication. Next, we have arbitration, which is a way to solve the dispute through a formal process. There are many advantages to arbitration, since its award or final decision is legally binding, and it is kept like has some level of customization and voluntary. Like to use arbitration, then both parties need to include the arbitration clause in the contract, or they need to agree expressly about the use of arbitration by a separate agreement. Or and in arbitration, then the party may customize their approach, like they can decide how and why and with which method they may go through arbitration. They may join arbitration through purely online resources, online tools, like through Zoom meeting, or they may customize the process that they only need to submit the document instead of arguing the case in person. Okay, that can reduce cost. Anyway, then arbitration could be a quick way and also confidential way to resolve the dispute, although it could be quite costly. And the cost for arbitration is basically more expensive than litigation. Okay, you can search for some arbitration panel, commercial arbitration panel in your country, and you can see, you can look up for the procedure as well as the cost of those services. Finally, we have the litigation that is going through the solving dispute through a court system, and every country has a court system. And then in that system, then you need to submit the evidence, you need to wait for the hearing, and you need to wait for the decision. So the time for litigation is very long. But anyway, then the decision is enforceable, and the dispute and the person who solved dispute here is a legal professional. Therefore, you can trust their expertise in solving dispute and in their knowledge of the law. But litigation is costly. It requires you to go through some lawyer if you don't know how to deal with this problem. So you need to contact a lawyer, and that could be costly for the parties here. Furthermore, litigation also require it to be public, except in case that there are some real concern about the confidentiality. So litigation must be public, and therefore, it may disclose that it may disclose some sensitive information that the party may not want. So currently in commercial business, then the parties may prefer adjudication or arbitration due to its confidentiality and quicker or shorter time frame to solve the dispute. Finally, we may look at a small topic about different consequences of breach. A breach could require or could allow the innocent party to claim for damages or to terminate the contract or to perform or to enforce certain performance or to impose certain injunction. So let's look at each option. Actually, yeah, let's look at each consequence. With the damages, then the law already have some standard for assessing the damages. Except the case that we have liquidated damages, then the law always has some way to estimate the damage, like using the expectation or using the reliance method. Expectation method is the basic for assessing the damages. It measures the damage that is equal to the position of innocent party they would have if we have if the contract is duly or properly performed. Like if the supplier deliver that goods on time, then you'll get certain benefit. And if they don't, then you suffer some damages, like you may um, lose a certain deal, or you may miss some opportunity, or you may incur some damages during the wait for the delivery. So you can claim all of those things to the court, and they may decide using the expectation method, okay, by the damages that you have suffered. With reliance method, then it focuses on compensating the innocent party based on the cost that they have paid for the contract to be performed. Like we have a contractor, we have an investor and a contractor in construction, and the investor may sign contract with the contractor about building certain house, but but the investor may decide to terminate the contract early, and that may cause some damages to the contractor. Especially, they need to contact the employees, they need to arrange the material, and they need to sign the contract with other party. So the cost of preparing for or mobilizing for the contract for the investor will be the damages that the investor need to pay. Okay, so that is an example of reliance method. We also have the restitution method, but I think that you can ignore that a little bit because it requires very special case of damages here. There are two other methods based on the equity, and they need to be awarded by the court. We can refer to specific performance and injunction. They calculate opposite to each other. Why specific performance is like an order, a court order for a party to fulfill the contract obligation. Then injunction is an order to refrain something. Okay, refrain from doing something, like they must not do something. So the court may consider these things when they see that the damages are insufficient to compensate the innocent party. So they calculate the method or remedies that for equitable measure. Now, I have a small question for you. Okay, that is a matching question. And as usual, then we have the price. That is Lighthouse access for one of our practice tests of choice on Udemy. Or you can select the Netflix gift code or $15 mobile top up. Today, I only have one question, but it is matching. So you need to decide correctly. And we only award this prize to the fastest answer with, uh, yeah, I mean, we only award this one to the first correct answer to our question. Right. So we have a matching question. Just look like in the exam, but let's see how you answer this question. Right. So it is a question about negotiation and different type of contract terms. So you need to match between different stages of the negotiation and the right contract term. Now, let's start the question and see who wins this small prize. Yeah, we have a small question. You need to read it. You need to decide what will be the answer. Okay, so the price is waiting, and I expect that I should receive some answer soon. Yeah, I think I need to limit the time. Okay, we cannot wait forever. I expect to receive the answer 5 minutes from now. Um, we still have 1 minute until time's up. So if you want to get a free question for lifetime access, then you need to answer quickly. Let me know how you solve this question. All right, thumbs up. So so far I don't receive any answer. Unfortunately, yeah, we need to the prize need some winner later. Okay, so let me review the answer. This is the answer. The first stage is opening, which is to break the ice between Sally and Juan. And it is about specification and quality standards, so must be about testing and acceptance. Yeah, that is the contract term here. Second, Sally is quite proactive and she suggests the first offer, that is proposal. And um, she preferred to have a dispute resolution to be confidential and to protect their privacy, but guarantee a binding outcome. So the second one must be about dispute resolution, and the answer is arbitration. Step number three, Juan also have something in return, that is bargaining, right? Caroline didn't that, right? Exchange the idea and exchange the concessions. So he wants to have some guarantee or some assurance of payment. Therefore, that is about guarantee, where Sally's company is quite small and has no credit history. So Joan needs some kind of assurance here. And therefore, we have guarantee. And finally, of course, it is the agreement. Okay, so but they talk about some liability exclusion clause. That is force majeure. Okay, about either prevent a war, natural disaster, or pandemic, and that may prevent a party to perform the contract duly. So that is exclusion of liability or force majeure. So this is the final answer. We have opening and testing acceptance at the first stage, proposal and arbitration in the second stage, bargaining and guarantee at the third stage, and agreement and force majeure at the fourth stage. All right, so this is the answer. Unfortunately, today I don't receive any answer. Okay, it's all blank. So the prize will be deferred to another event. Okay, so before we leave, then we already provide the present question for L5M3 and also with some small videos and the answer to the study guide questions on Udemy. So if you want to purchase and you want to study better, prepare better for the exam, then apply this code Happy 2025, and it may give you the best discount for the current for the current price. And remember that today is the final day of the promotion. So be quick or you may miss the opportunity. If you have any further concern, then just contact us on WhatsApp and email. And thank you so much for joining us today. Yeah, I hope that you have learned something important for L5M3, and see you later in other event. Goodbye and see you.